Hi guys, today Steward and I will be presenting problem set 9 question number 3. This question deals specifically with a company's accounts and audit, and this question can be found here. So to begin this presentation, let us first discuss and dissect the meaning and gist of this question. The question begins with a very general statement that says directors are under the obligation or are required to state whether or not, in their opinion, the companies can pay its debts as and when they are due. This basically means the directors are obligated to give a statement whether or not, in their opinion, the company is in a healthy financial situation. From this general statement, there are two questions posed. First, what does this obligation mean? And the second question is, what is the implications of this obligation onto the directors? During the course of this presentation, any provisions of the Companies Act in which we refer to will be listed here, and it will be accompanied by this sound. On the other hand, any cases that we refer to will be listed here and accompanied by the same sound. Therefore, without further ado, we promise not to take up too much of your time, so please bear with us for the next 8 minutes or so, in which Steward and I will try our very best to explain this question as clearly, concisely, and comprehensively as possible. Before we dwell into the meaning of this director's opinion, there are 3 preliminary issues that we have to handle first. First, we have to understand that under Section 165, every company must lodge its annual return before the Registrar of Companies. The second preliminary issue is, by virtue of Section 169, subsection 1 and subsection 3, every company must prepare their profit and loss accounts and balance sheet within a stipulated time. And finally, the third preliminary issue is these financial reports, which encompass the profit and loss accounts and the balance sheet, must be duly audited, and this is found under Section 169 subsection 4. Now, I know you guys might be wondering, what does the financial reports have anything to do with the director's opinion? Ladies and gentlemen, the answer to this question is very simple. In fact, these financial reports have everything to do with the director's opinion. This is because the director's opinion are based upon the profit and loss account and the balance sheet. In actuality, the term opinion is a general term to encompass 3 things, which are the director's report, statement, and declarations found in the provisions as stated here. These 3 instruments are an endorsement and acknowledgement by the directors that the financial reports are a reflection of the true and fair value of the state of affairs and the business of the company. Now, the question does arise, what is the threshold for true and fair value of a company? To answer this question, we refer to the case of Richard Charles Tarling against Public Prosecutor. From this case, we can see that the threshold for true and fair value of a company is merely if the accounts audited and submitted before the Registrar of Companies is not misleading. In summary of the first question, the opinion of the director that the company can pay its debts as and when they are payable is an informed statement. This statement is reliant upon the company's profit and loss accounts and the balance sheet. It is noteworthy that all these financial reports that the directors rely on must be duly audited, and therefore I now pass the floor to my partner Steward, who will explore to what extent an auditor's misconduct may adversely affect or incur liability onto the directors.
Good day everyone,
Thank you.
My name is Steward, and as introduced by my friend Alex, I would be dealing with the second part of the question. Alex has dealt with Section 169 of the Companies Act. Moving on, I will deal with what are the implications of these requirements on the duties of the directors. I will start by outlining what is required under the law, or what definition has been given to the term true and fair when the directors are carrying out their duty to provide a profit and loss account. In essence, a company's director merely has to take reasonable steps or precautions when giving their statements, to include steps that are taken to write off bad debts, or whether provisions are made for doubtful debts. If the accounts are deemed to be not true and fair, a company's director may be prosecuted under Sections 171, subsection 1, which carries a punishment of imprisonment up to 5 years or a fine amounting to 30,000 ringgit. Examples can be seen in cases such as Rubathok versus Public Prosecutor. The company's director has been sentenced to 3 years imprisonment for criminal conspiracy to cheat by window dressing the accounts in order to deceive customers dealing with the company. Since the failure to provide an account which is true and fair entails such a liability, we will have to next look into what is required under the law on the threshold of the duty of care and diligence required by the directors when they are carrying out such duties. Generally, directors or officers of the company are required to exercise a reasonable duty of care and diligence when carrying out their duties to the best interest of the companies and the stakeholders of the company. These duties are imposed under Section 132, subsection 1A of the Companies Act, which was introduced by the Companies Amendment Act 2007, as well as the common law tort of negligence. Additionally, the test for this duty has been given a lower subjective threshold, as can be seen in the 1925 case regarding City Equitable Fire Insurance Company Limited case, whereby the standard of care required is measured by reference to a person to what is reasonably expected by a person with the same expertise or skills. What this basically entails is, the less knowledge and experience possessed by a company's directors, the less standard of care is required by him. However, this position has changed significantly, as can be seen through the landmark case of Daniels versus Anderson, where an objective approach has been used to impose contributory negligence on the executive directors of the company AWA in addition to the auditors of the company. In that case, the executive directors has failed to exercise a reasonable duty of care by failing to make inquiries that would have led to a better appreciation of all the aspects of the company's business operations. In Malaysia, both the subjective and objective approach in determining the required duty of care has been incorporated into our statute, which is the Companies Act, under Section 132(1)(a). Generally, the individual circumstance of the director is considered. Next, the court will assess what is reasonably expected from a person in the said circumstance. It is generally understood that the profit and loss accounts and the balance sheets of a company would be prepared by auditors of the company, and Section 132(1)(c) has provided that the directors of a company may make reliance on professionals and experts. In regards in this particular duty in our present case, would be the expertise of auditors of the company. However, Section 132(1)(d) of the Companies Act states that this reliance is only made on reasonable grounds if it is made with good faith and that the company's directors has made independent assessment on the information. Therefore, looking at the provisions and the requirements imposed on the directors as a whole, the implications is that the directors of company has to take precaution and reasonable steps as expected from a reasonable person in their position to ensure that the profits and loss accounts are true and fair so as not to amount to a misleading account. Even in cases when the accounts are prepared by auditors of the company, they may still held to be liable through contributory negligence in the event they fail to take reasonable steps to make proper inquiries before submitting the report and statement. Thank you very much.